All right, let's talk about a journey, a 250-year legal battle, to be exact. We're going to go from a time when a woman's entire legal identity could just disappear when she got married, all the way to the fight for the ballot, for equality at work, and so much more. This is a huge story, so let's dive right in. Okay, so to really get a grip on this whole fight for women's rights, you got to know where the starting line was. And believe me, it was way, way back. When the US was founded, the legal rulebook for women wasn't some new American idea. Nope, it was basically copy-pasted directly from English common law. And that set a pretty bleak stage for what was to come.
I mean, just let those words sink in for a second. Suspended legal existence. That's not poetry, it's not a metaphor. That was the actual, literal legal reality for married women. In the eyes of the law, you were basically a ghost. And there's a name for this whole concept. It's called coverture. So, what did that mean in real life? Well, it meant a married woman couldn't own property in her own name, she couldn't sign a contract, she couldn't even keep the money she earned. Her entire legal identity, poof, just got swallowed up by her husband's. This wasn't some rare exception. This was the default setting for women in early America. Now, you can probably guess that a system like that wasn't going to last forever without a fight, right? It was just bound to spark some serious resistance, and it did. That resistance grew into the very first massive organized movement for women's rights, a long, tough, grueling battle for one single thing, the right to vote. And wow, this timeline really puts it all into perspective, doesn't it? We're talking from the Seneca Falls Convention in 1848 all the way to 1920. That's 72 years. Think about that. That's longer than many people's entire lives. This was a fight passed down from mother to daughter. So many of the women who kicked this whole thing off never, ever got to cast a vote themselves. So, a huge turning point in this fight actually came from a pretty unexpected place, the 14th Amendment. Now, this amendment was passed after the Civil War to deal with citizenship for former slaves, but it had this one little detail buried inside that changed everything for the women's movement. For the very first time in the Constitution, the word male was used to define voters. That one word, it was like a lightning bolt. It totally lit a fire under leaders like Elizabeth Cady Stanton and Susan B. Anthony, and made them realize they had to aim for a federal amendment. But that same moment also created a huge rift in the movement. People just couldn't agree on the best way forward. So it split into two main camps. You had one group, the NWSA, that said, nope, we're going for the big prize, a federal amendment, one and done. Then you had the other group, the AWSA, which argued for a slower approach, winning the right to vote one state at a time. So you have these two groups, sometimes working against each other, sometimes in parallel. But after decades of marching, petitioning, and endless debate, they eventually joined forces again. And that unified push is what finally got them over the finish line. In 1920, the 19th Amendment becomes law. The language is so simple but so powerful, and it changed the American electorate forever. Okay, so they won the vote. Huge victory, right? But it wasn't the end of the story. Not by a long shot. It was really more like the end of the beginning. The fight for true equality was just getting started, and it was about to move into all sorts of new and complicated areas, from the courtroom to really personal questions about bodily autonomy. And you know, those old ideas about a woman's place, they were deeply stuck in the legal system. I mean, get this, as late as 1961, that's well into the 20th century, the Supreme Court was still saying that a woman's main job is in the home. And they used that logic to uphold a law that basically let women off the hook for jury duty. The thinking was they were just too busy with family life. But then, just a decade later, something huge happened. A total seismic shift. In a case called Reed v. Reed, the Supreme Court looked at a law that said men should be preferred over women when it comes to managing an estate, and they struck it down. Now, here's why that's such a landmark. It was the very first time in American history that the Supreme Court said a law was unconstitutional because it discriminated based on sex. A massive turning point. And once that door was opened, this new way of thinking started getting applied to other areas, especially reproductive rights. You can see a clear progression here. First, in Griswold, the court says, hey, married couples have a right to privacy when it comes to contraception. A few years later, in Eisenstadt, they extend that same right to unmarried people. And that idea, that fundamental right to privacy, became the legal foundation for the famous Roe v. Wade decision in 1973. And while all this was happening in the courts, Congress was busy too. In 1972, they passed something called Title IX, and it was an absolute game changer. The rule was simple. If a school gets any federal money, it can't discriminate based on sex. Period. This just blew the doors open for women and girls in education. And of course, it completely transformed women's sports. So you have more equality in the classroom, more equality at the ballot box. It was only natural that the next big frontier was going to be the workplace. And just like before, the fight for equality there would be its own dramatic story, full of huge wins and some pretty tough setbacks. So during the 60s and 70s, Congress basically built three huge pillars for workplace protection. You've got the Equal Pay Act of 1963, which said you can't pay women less for the same job. Then came the massive Civil Rights Act in 64, where Title VII banned employment discrimination based on sex. And then in 78, the Pregnancy Discrimination Act made it illegal to fire a woman just for being pregnant. Together, these laws created a whole new foundation for women's economic rights. But, foundations can get shaken. And that's what happened in 2007 with a Supreme Court case called Ledbetter v. Goodyear. The court's ruling was tricky. They said that if you were being paid unfairly, you had to file a complaint within 180 days of the very first time it happened. Not the last time, the first time. As you can imagine, most people don't even realize they're being underpaid for years, so this made it almost impossible to actually file a claim. And this is where things get really interesting, because you see this fascinating back and forth between the courts and Congress. The Supreme Court makes a ruling that basically closes a door for a lot of people. So what does Congress do? They step in and say, okay, if that's how the law is being interpreted, we'll just write a new law. It was a direct response, a legislative fix to a judicial problem. And that's how we got the Lilly Ledbetter Fair Pay Restoration Act. The fix was actually pretty simple, but it was incredibly powerful. The new law said that the 180-day clock to file a complaint resets with every single discriminatory paycheck. So it didn't matter when it started, it mattered when it last happened. This gave victims a real fighting chance to seek justice and showed how Congress can step in to clarify and strengthen protections. So all of that brings us pretty much up to the present day. And it's a powerful reminder that this 250-year story, well, it isn't over. It's a living history. The journey is still happening right now, with more progress being made, but also with some really significant new challenges popping up. And just think about the incredible firsts we've seen in recent decades. Sandra Day O'Connor becoming the first woman on the Supreme Court, then Ruth Bader Ginsburg joining her, Nancy Pelosi taking the gavel as the first female Speaker of the House, and of course, Kamala Harris becoming the first female vice president. Each one of these was a milestone that for generations was pretty much unthinkable. And the work in Congress keeps going. As recently as 2022, the Violence Against Women Act was passed again, but this time it was made even stronger, boosting services and protections for victims of domestic violence and sexual assault. But that very same year, 2022, also saw a massive legal shift in the other direction. In the Dobbs v. Jackson case, the Supreme Court overruled Roe v. Wade. The decision stated that the Constitution doesn't actually confer a right to abortion, which means the power to regulate it or ban it goes back to each individual state to decide. Even with all these legal debates, the push for representation in government keeps moving forward. In fact, as of 2023, there was a record number of women serving in the U.S. Congress, 153. That number is it's a really powerful symbol of just how much has changed in the centuries since women first won the right to vote for those seats in the first place. And that kind of leaves us right here, in the middle of it all, with a big question. This long, complicated, sometimes messy legal journey is clearly still being written. After 2.5 centuries of struggle and evolution, the only thing we know for sure is that it's not over. So the question really is, what does the next chapter hold?